Let me develop it. I'm answering only my Lord's query. Paramount is substance, the heart of the matter. It is true that on that day, on 29, nobody would know what would politically happen on 30th. And it is true that the technical word used is trust vote. But what was allowed to go on was a test on the floor, which is inevitable if 39 vote against. The one and only foregone conclusion, instead of suffering the humiliation of a vote, is to give up in advance. I mean, we are in a real world. There is no arithmetic, no science, no physics, which can change the result on 30th. If these people who comprise this, so the floor, I argued the matter on 29th and the earlier dates. One of the main arguments was that the moment your lordship permits these people to vote, we were seeking an injunction. How can there be a trust vote with a tainted, how can you have a swimming pool with some part of it tainted with poison?
No, therefore your submission seems to be
that was not accepted.
That not granting the injunction,
yes,
correct, would in fact had facilitated those 39.
No, it was an additional argument, I'm very grateful. One argument was that this trust vote is completely unreal and futile because you have not excluded the tainted fruit.
On the other hand,
the other argument was that if your lordship has stayed that, stay this also. That was a more important argument.
The flip side would have been that
stay both.
Dr. Singhvi, if you had faced the trust vote,
yes,
on the 30th,
yes,
these are open. This is an open vote.
Yes, yes.
Right? Because you have to, because that's the whole principle of the whip. If you had faced the trust vote and lost, then it would have been clear as to whether these 39 people made a difference, how they voted, and whether that made a difference to the ultimate trust vote.
So we did not do it. It's a given fact. I can't change it. Right,
Right.
I'm answering. Let me answer this also.
And the voting pattern would then determine as to whether these 39 who are otherwise facing disqualification motions,
yes,
whether they affected the trust vote or otherwise.
I appreciate. No.
If you had lost the trust vote only because of these 39,
yeah,
then you absolutely a plausible point that, look, these disqualifications, if they get disqualified, then I win the trust vote. Isn't it?
Let me. So the first part is the conceptual.
I mean, the area is not free from doubt. The reason I'm putting it to you is because there is a constitutional question in our mind. That's the.
I hear your lordship loud and clear.
Yes.
Let me, because certain given facts for us, we can't argue about. The fact of the matter is, nothing happened on 30th. The man did not go to the trust vote. No doubt about it. Now, the first conceptual answer is, we are now on what I have been saying and Mr. Sibal has been saying earlier were legal errors. Whether they were or not, the lordship will decide on 22nd, 23rd orders. But the argument regarding 29th order was that either you should not have stayed that, but if you stayed that, stay both. You can't stay that and allow this vote to go on.
Right.
That's the first point to be remembered.
If you have stayed the disqualification, then stay the trust vote also.
It's very unfair and uneven and non-level. If your lordship is hearing the matter next week, I believe it was on a Monday next, it was listed. Then both could have been held afterwards. The lordship as well as in the Karnataka late night matter we did, the lordship said, not today, next morning, it will happen at so-and-so time. The reverse is also true. Don't have it there, have it after 4 days.
So your argument to therefore restate your argument, what you are really arguing is this, that once you stayed effectively the speaker from deciding the disqualification petition, then you should have stayed the trust vote also, because one was linked to the other at the least.
The word linked, inextricably intertwined, absolutely. And that is the answer, the first answer on the conceptual query raised by my Lord Justice Shah.
No doubt.
It is true. Technically, one is a trust vote, one is a floor test, one is nobody comes.
But you're right. I mean, because
substance
at the trust vote, those people were going to vote.
So that's the first.
That-
Now, second, no, I will go further. Since your Lordship has put a different question.
But still, Dr. Singhvi, the problem still in your path. I mean, the problem still arises.
It would have been
that-
shown on that.
The
Definitely.
consequence of these 39 would have really.
No, so let me show.
At the trust
Therefore, therefore, now that will not affect this question. Let me be conceptually clever.
Yeah.
My Lord's query is right, but that will not affect the question I'm arguing now. That will affect, as and when your Lordship takes up the disqualification and says that we find that no disqualification occurs because we don't have sufficient proof to disqualify. That's all that will mean, Maharaj. It will only mean that I have insufficient evidence. And I'll tell Lordship why Lordship.
Nabam says, applying Nabam here, the speaker could not have decided. I'm not putting that against you, but I'm just trying to analyze.
As the principle today stands.
As the principle today stands.
Correct.
Nabam says that where a motion for the removal of the speaker is pending, he cannot decide the issue of disqualification. You say refer Nabam to a larger bench. But suppose you take this, that these 39, that Nabam therefore should not be construed to prevent the speaker from deciding disqualification.
Yes.
And these 39 were therefore liable to be excluded because the speaker would have been justified in hearing the disqualification, notwithstanding the pendency of the motion to remove him, that the speaker would have disqualified these 39 because, as Mr. Sibal said, it's a per se disqualification, it's a clear split. What is the ultimate consequence? That these 39 have to be taken out of reckoning on the trust vote which takes place.
My Lord is back to the chart figure.
Which these 39 have to be taken out of
reckoning. We have answered the governor point. Lordship is not coming to the governor. Governor is constitutionally barred. I'll deal with the chart in a minute. Well, today, can your Lordships proceed on hypothesis upon hypothesis? What would have happened had this happened? But I will satisfy that conscience also. Well, first part of my Lordship's
Did you not really?
The governor could have acted on that.
Did you not preclude a consideration of this argument by your own
Definitely
failure
answer
to
all.
face
I'm very grateful.
the legislative assembly?
So there are 2 or 3 answers.
Because also, I'll tell you why, and we'll rise then and we can reflect on this at lunch. Because today, what you are really asking for, and we're not saying that you are wrong in asking for it, because first principle, the court said subject to the outcome. So therefore, we have to now treat it, if we come to the conclusion that you are right, then ignore all outcomes.
And my Lords have done it twice. In
Fair
10
enough.
scheduled cases of big moment. Twice.
Fair enough. But before a constitutional court does that, namely to set back a status quo ante constitutionally, we must be in a position to say that, there is an arguable outcome which would matter.
Absolutely.
Which would make a difference.
Absolutely.
If whether there would be a difference or not is really foreclosed by virtue of the fact that you prevented that difference from emerging before the
why it is not foreclosed. I understand, my
Let this think on this.
I'll
We come
share
back at
with
lunch.
As I start, I have one request. I want to maintain the discipline of the Constitution bench. So I'm requesting your Lordships to give me 5 minutes when your Lordship assembles at 3 o'clock on a most extraordinary urgent mentioning. I won't do it now because it's a Constitution bench. Your Lordship is fortunately rising at 2:55. So I'll do that before the other matter starts. And your Lordship will take it that I'm not abusing the process. Your Lordship hears what has happened. But that apart, now let me continue with this.
The mentioning is unrelated to this matter.
Unrelated.
Because I was only looking at the
unrelated.
point of view of the bench. Then Justice Narasimha and I will come back for the mentioning, and then I'll assemble in the.
Nothing to do with
No, nothing to do with this. Well, it's with your Lordship's permission. Well, it's a senior person, in public life called Pawan Kheda was boarding a flight today at around 11 o'clock. At the flight, inside the flight, he was deboarded on 3 sets of complaints, Varanasi, Lucknow and Assam. The section invoked is 153A, 153B, national integration and enmity between groups. And based on a statement, I'm not at all justifying any statement, I may not use that language, he may not, but was based on a statement in a press conference and sought to be whisked away at the moment they are at the airport. And being taken away by Assam police at Delhi airport. Therefore, till 3 o'clock they are there, and I'm showing that this cannot be a possible. We are asking for consolidation because now all over the country they are filing these affairs. And with consolidation, well,
Who's
this
Mr.
stay of
Pawan
arrest.
Khera?
Stay of
Who's
arrest.
Mr. Pawan Khera?
Mr. Pawan Khera Malas is a spokesperson of the Congress, and Malas, he has frequently Malas, had interactions with the press. He may, I will for a moment without going to the merits, have made a statement which Malas, many people would not make, personally I would not make. But the
What have you
statement,
got?
I don't want to Malas, I can repeat the statement,
We'll
but
take
I
it
don't
up.
want to repeat
We
it.
take it up at 3 o'clock or
That's all I'm saying.
3 o'clock is fine, no?
Yes, 3 o'clock.
Then, okay.
Please tell them till 3 o'clock. Yes,
Have you got some petitions?
yes, Malas, we have got the provisional number. We'll have hopefully a diary number, but at least a provisional number in 3 sets.
All right.
Now, Malas, your lordships put that question just on rising. So let me answer, Malas, ABCD, that particular question. I'll continue with my sequence after, but lordship put that question, that had you allowed possibly the 30th vote to have worked itself out or other things, then your lordship would have had, so to say, an actual
Chetan,
test.
3 baje
To come with the court master. Now, Malas, so therefore, you should have allowed that to happen, and then we would have had some idea, is what your lordship put in a nutshell. Malas, there are 5 very interesting answers to it. Directly to your lordship, very important query. And Malas, a related query of Justice Shah at that time. A. Malas, this act was followed on 30th by the swearing in along with BJP persons. Just note, well, I'll make the point in a minute. Just note, 30th June was the swearing in along with Malas, senior members of the BJP. 3rd of July, 3 days later, the direct answer to my Lord's query, not on 30th, I agree. Nothing happened on 30th in terms of the vote. But exactly the same trust vote, if your lordship will call it, or a vote of a virtually identical nature happened at the speaker's election. Now clearly, Malas, there is a whip, there is a direction, you can't vote for the speaker, you are my party, you cannot vote. Voting was done. These 39 odd voted the other way. No proof is required, Malas. This is a 2-1B without going into a single fact.